Hey, I'm coming up on my 24,000 miles in New Jersey. Should I stop driving it? I should, right? No, absolutely not. Absolutely continue to drive it. As long as those visits were within that time period, we can certainly make a lemon law case. It doesn't matter how many you have on it now.
Hi, I'm Emma.
And I'm Courtney.
Welcome to Lemon Law Unpeeled, the Lemon Law podcast. Today, we're going to take a bit of a deep dive into lemon law and how it varies state by state, different government agencies that are involved, different requirements per notice, and things of that nature that a consumer has to take or may not have to take, depending on the state prior to starting a lemon law claim, and different case law and things like that that have come into effect that may change your rights or remedies, depending on what state that you're located in. So first, I guess, let's just quickly talk about state-specific eligibility. So Courtney, I know you've been doing PA in New Jersey pretty exclusively for some time now. We've branched into other states, but I'll have you sort of kick it off with those two states and talking about their requirements and eligibility.
Yeah, absolutely, Emma. So as you mentioned, most states do have varying requirements. Some states require that the vehicle be both purchased and registered, oftentimes first registered, not just registered currently in a specific state. Other states require that the vehicle just be purchased or just be registered in that state. Pennsylvania, for instance, requires that the vehicle be both purchased and registered in the state of Pennsylvania. New Jersey is the opposite. It's either or. Just requires that the vehicle be either purchased or registered in the state of New Jersey in order to avail yourself of either the Pennsylvania or the New Jersey lemon laws.
Exactly. And for some reason, every state's different on this. Maryland, for example, it only needs to be registered there. In Ohio, you need to purchase there. In Georgia, it either has to be purchased or registered in the state in order to qualify. So every state's a little bit different in terms of what they need to see in order for you to use their lemon laws to your advantage. And additionally, not only do they differ on those requirements, but they also all have different timelines and time limits for bringing these claims. So again, Courtney, I'll let you talk about PA, New Jersey, and New York, and I will handle Ohio, Georgia, and Maryland.
Yeah, absolutely. So Pennsylvania requires that the vehicle be brought back to the dealership within the first year or 12,000 miles. It requires a total of 3 visits, but only that first one has to be within the first year or 12,000 miles. New Jersey, a little bit different. It's a longer time period and mileage availability of 2 years or 24,000 miles, but the vehicle has to be back all 3 times within those 2 years or 24,000 miles. So it's kind of a double-edged sword. Is it better than Pennsylvania? Is it more consumer friendly than Pennsylvania or not? The requirement is larger, but again, all 3 have to be within that period of time rather than just the one. New York is a little bit, it kind of takes a little bit of both. New York, the vehicle has to be back 4 times within the first 2 years or 18,000 miles. So that's probably the most difficult one because it's 4 times, it's only 18,000 miles, not 24,000 miles. Fun fact, New Jersey actually used to be just 18,000 miles, probably until about 2008, 2009, somewhere around there, and then switched to 24,000 miles. New York does still cut it off at 18,000.
And to be clear, the mileage starts from when the original person purchases the vehicle. So for example, in New York, I have some clients saying, well, I've only had the vehicle for 5,000 miles. When I purchased it, it already had 13,000 miles on it. And this is where some states differ too in terms of new versus used, which we'll get into in a moment. But it's important to note that these time limits start from when the vehicle is initially put into service. It's not how many miles you have put on the vehicle.
Yeah, that's a really good point, Emma. I have people all the time say, well, I just purchased it last month. I've only been driving it for 100 miles. Unfortunately, if the vehicle's odometer is over this mileage or the original in-service date is more than 12 months or 18 months or 24 months, depending what state you're in, you're out of luck under the lemon law. It's the vehicle's history, not your own history with the vehicle.
Right. And Maryland actually functions very similarly to New York. You have to have 4 visits or 30 days out of service within the first 2 years or 18,000 miles of the vehicle's life. And it's important to note that most lemon laws, whether it be 3 or 4 visits, all have this caveat where the problem must continue after you hit that marker. So after you hit the 3 visits or after you hit the 4 visits, they generally all say and continues. Up in the air, as we have talked about previously, as to whether after, let's say you have your 4 visits and it continues, if it's fixed on the 5th visit, does that mean that you're no longer eligible? That's just, an argument we have. The law really doesn't clarify that for you, but you do have to show that it continues once you hit that mark. Ohio kind of has its own thing going. You have to have 3 visits or 30 or more days out of service within the first year or 18,000 miles. It does also have a caveat that you only have to have 1 visit and the problem continues to exist for a defect that can cause serious bodily injury or death. And New Jersey actually has something similar to that too. It actually says pretty much the same thing. They only get 2 chances essentially to try to fix this type of a defect. And Georgia says that you have to have 3 visits or 30 or more days out of service within the first 2 years or 24,000 miles of the vehicle's life. So they all kind of have their own thing going in terms of what they want to see and what qualifies. And similarly, Courtney, I'll let you touch on the whole new versus used issue when it comes to lemon law as well.
Yeah, absolutely. Generally, the states do want to see that the vehicle be new. Pennsylvania, the vehicle does have to be new. New Jersey doesn't technically have to be, providing that it be less than 2 years or 24,000 miles. That said, practically speaking, I don't know that I can remember getting a buyback on a vehicle that wasn't brand new. So sometimes the law does kind of have these little caveats, but that doesn't mean that we generally see them in practice.
Right. And we've talked about before, sort of the letter of the law versus its interpretation can be different. And similarly, so in New York, the vehicle, again, can be new or used. You just had to have purchased it before it hit 2 years or 18,000 miles. And New York and New Jersey both also have a used car lemon law that basically covers vehicles purchased outside of that time period. So let's say you purchased a used vehicle in New York that was only 1 year old when you got it and it had 10,000 miles on it. Even though that vehicle is technically pre-owned and you're the second owner, you would fall within the new car lemon law in New York because you purchased it within that 218. The used car lemon law for New York or New Jersey has other requirements that are outside of this new car lemon law that can kind of catch any other vehicle that doesn't fall within those timelines. But used car lemon laws are a topic for another day because they are also their whole other, own animal and have their own requirements and things that need to be seen in order to qualify. And those cases are generally against the dealership or the selling dealer as opposed to the vehicle's manufacturer, like the new car lemon laws are. But we're just going to stick with the new car lemon law today. Maryland also requires that the vehicle be purchased new, and so does Ohio and Georgia. So really New York and New Jersey, it seems, in the, of the states that we practice in, are the only ones that let it slide if it's used. But again, as a practical matter, it can be kind of tough to get lemon law on a used vehicle. Now, along with the duration and time limits that we just talked about in terms of, the 224 in New Jersey or the 218 in New York, a lot of clients ask me, hey, I'm coming up on 19,000 miles. Should I stop driving my car? Or what does that mean for my lemon law claim? So as we usually, discuss with them, the states just want to see your visits within that time period. Your vehicle doesn't have to be within the 218 when you're pursuing your lemon law claim, right? So if we are still in the middle of negotiating or we're still in the middle of litigation and your vehicle turns, 2 years in a day and you hit 18,001 mile, you are not then kicked out of lemon law. They just want to see that the visits and the defect occurred within that time period for you to qualify. It's really important to know that it's not an automatic thing, right, Courtney? Just because you have these visits in this time period does not mean, hey, your vehicle is automatically branded a lemon. There's nothing automatic. That just gets your foot in the door.
Yeah, absolutely. I have clients mention both of the points that you just made. One, hey, I'm coming up on my 24,000 miles in New Jersey. Should I stop driving it? I should, right? No, absolutely not. Absolutely continue to drive it. As long as those visits were within that time period, we can certainly make a lemon law case. It doesn't matter how many you have on it now. But yes, to your second point, exactly. It is nothing automatic. I also have clients who say, here are my 3 times. Where's my new car? Unfortunately, it's not as simple as that. That allows us to make the argument, but that doesn't mean we're necessarily going to get it. Generally, we are able to, especially if it is a substantial defect, something that is substantially impairing your use value or safety, because that is what the law requires. But unfortunately, not all defects do that, especially in the court's eyes, and something that you or I or our clients may think is substantially impairing the use value or safety to us. The court doesn't necessarily see it that way. So yeah, it's not an automatic thing, unfortunately.
Yeah, that's what I always explain to clients is that so lemon law technically is 3 parts, right? You have to have the mileage and time down. You have to have your visits. And then the third part is the substantial impairment. And the substantial impairment is the piece that makes lemon law not an automatic thing because it's up to the eye of the beholder. What one person might think is a substantial impairment, another one doesn't. We have some in your face lemon law claims, right? Driving 60 miles an hour on the highway, my car completely stalled out on me. Good luck trying to argue with us that that's not a substantial impairment. That impairment itself clearly would be one that's very significant. But then sometimes we get into gray areas, right? Like my transmission is hesitating. My transmission is banging into gear. One person may think, hey, that's a big deal. That's substantial. Someone else might be like, meh, I could live with that. So that's what makes it kind of wishy-washy is that whole prong of lemon law. And then we could get into the whole thing of whether it's been duplicated, whether the dealership says, yes, we find an issue, we haven't found an issue. All of these things kind of are what throw lemon law up in the air.
Yeah, absolutely. One of the hot button issues kind of for us is those safety features that are in so many vehicles now, the lane assist warning, the collision mitigation warning, backup cameras. So many clients will say, well, that's a huge safety thing. If I'm trying to back up and there's toddlers who live next door to me and I can't see if they're behind my car or not, how can you possibly argue that that's not a safety impairment? But unfortunately, the courts generally look at that as not substantially impairing use value or safety because for decades and decades, people were able to drive their vehicles without backup cameras. Generally, what the law is looking for is the vehicle still able to get from point A to point B? Is it steering, braking, and accelerating? That's generally what it's looking for. But we are able to make the argument with all of these other things. And what one court may accept, another court may not. So it's something that we're always willing to make the argument for.
Because that's not to say, I have gotten a buyback on a backup camera case before. Is that the norm? No. I was surprised. And there were a lot of other factors that go into it too. Like it is a case by case thing. In this case specifically, the car was sitting waiting for a part and that part had no ETA in sight. So that also comes into play as well, along with the impairment, right? They didn't have a timeline for fixing it. So everything, has to be considered. Lots of different factors that come into play when you're doing lemon law. Just in a nutshell, I guess it's just that it's not an automatic thing. It's not 1, 2, 3, boom, you're done. It's a lemon. There's so many factors that go into it. And one major factor too that a lot of people ask about is the role of state agencies when it comes to these types of claims. So your first probably Google of lemon law, the main results you're going to get, or at least the top 3 are usually, are reserved for government agencies, are basically the Attorney General's Office, the Better Business Bureau, and NCDS. So the Attorney General's Office is obviously a state-run agency. Every state has one. And they generally have a lemon law page that describes what the lemon law is in that state, what rights and remedies you have, and what notification you have to give to the manufacturer to have a claim. You then do have the right to bring your lemon law case through the Attorney General's office, which we generally don't do unless it's a requirement. So like Georgia, for example, you have to go through the Attorney General's office if you want to push your lemon law claim through. You don't have the right to go through, say, a civil court like you would in PA or New Jersey. But that can be tough, right? You're kind of putting all your eggs in one basket when it comes to going through the Attorney General's office, or the AG's office, as we may refer to it.
Yeah, exactly. Better Business Bureau was the same way. I used to go to the Better Business Bureau in most of our cases before we filed an official lawsuit. The problem with that is if you have a great lemon law case, great, because it's super quick. If you're going to get a repurchase under the lemon law, great. It's sometimes a way to fast track it. But it has to be an extremely strong case in order to get it. And you don't have that backup of breach of warranty. So whereas when we file a regular pre-litigation claim or a lawsuit, we argue both laws. We argue lemon law, or if the court doesn't feel that the case rises to the threshold of the lemon law and isn't going to award a buyback, we're then looking for money damages under breach of warranty. So we at least have that backup. Whereas with these state agencies, you can only recover under lemon law. So if your case isn't super strong and you're most likely not going to get that buyback under lemon law, going through these state agencies can sometimes be a waste of time, unless the manufacturer requires them, which is kind of a whole other thing that we can talk about because sometimes that does happen. But generally, when given the choice, we're just going to pass over these state agencies and go right to filing a claim.
Right. And sometimes, I mean, even with strong lemon law claims, I've had at BBB hearings or NCDS where they want the car there and the arbitrator wants to go out and they want to test drive the car. And a lot of these problems are intermittent. They don't happen every time you drive it. And so they'll go out, they'll drive the car and be like, nothing's happening. So there's nothing wrong. And then sometimes they don't. Sometimes they don't do that. It's a real toss up, and can be really difficult in determining, what is the, best course of action. And the Attorney General's office too, while we kind of steer away from it in some states like New York, is because they don't award attorney's fees and costs if you do recover under lemon law. So we'd have to charge our clients. And so since we have other methods and other means of getting that buyback other than going through that state agency, we don't, because then we can include our fees from the manufacturer as per the state laws, as opposed to having to charge a fee up front. And so, like I said, some states don't require you to go through the Attorney General's office at all. Some manufacturers, so this is kind of a hot button issue, right? Whether you have to go through the BBB and NCDS before filing your lawsuit against the manufacturer. So actually, if you check your warranty booklet, right, there's probably a pretty strong chance that in there's information on either the BBB or NCDS instructing you to file a claim with them if you believe that you have a lemon law claim. And what we're finding is that some manufacturers, if we just skip over that and go right to filing the lawsuit, some manufacturers will try to fight us on that. And they will file to get the claim basically kicked out of court, saying, no, you need to go through the BBB and NCDS first before you can file this lawsuit. And there's been lots of motion practice fighting on this. And it's sort of a mixed bag of results, but I do think the predominant result at this point is that, no, we don't have to go through them because, the way that they're interpreting it is that the point of the BBB and NCDS is to facilitate a settlement, right? To find an easy mechanism to get these claims resolved and not bog down the civil court system. But again, as Courtney said, we put all our eggs in one basket when we're going through that. So it does limit our rights and remedies. So we don't use them. And the courts have generally said that's okay if you don't use them, because they're not supposed to be a means for manufacturers to get cases kicked out of court. They're just supposed to be used to help facilitate a settlement.
Yeah, absolutely. And that's an important point. The courts want to decide these cases on the merits, not on a technicality. And so a lot of times courts in all motions, really, they're looking to, well, what was the intent of what you're trying to say should or should not happen? And as you said, the intent of these informal dispute resolution systems was to settle these cases, not to bar a consumer from bringing a claim. So that is, why we generally don't have to go through these. But Emma, you actually brought back a lot of memories by saying that, in the BBB, for instance, they want to go out and test drive the vehicle. And if they don't find the problem, they say, no lemon law remedy here. Brought back a lot of memories. I've done that many, many times. And it's usually a very awkward thing. This person that you've never met is going out there and they're driving your client's vehicle. And a lot of times you're in the middle of Philadelphia or the middle of a city. The person doesn't know where they're going and they're, almost hitting other cars. And then they're barely even concentrating on if they feel this hesitation or if they're or feel this transmission jerk or whatever it may be. And as you said, if they don't feel it, they're not going to award for you. So they're really not the best option for us.
We just generally don't go through them. And yeah, because it just, like Courtney said, we just find that the civil court system works better for us, or even like we had described in a prior podcast, just a letter to the manufacturer and let us just talk to them directly. Let us hash it out. Let's figure this out on our own, as opposed to putting, our fate in the hands of an arbitrator that, may or may not really know what's going on with the case. So we tend to choose other avenues or remedies when pushing these cases forward. So states do vary, because while the whole, going through the Attorney General's office or the BBB or NCDS is up in the air, there are certain requirements that Lemon Law does require of consumers when bringing a case forward. Again, it's a state by state thing, but basically what it comes down to is notice, right? Did you send proper notice to the manufacturer, giving them a final repair attempt before you went and filed your lawsuit? Because again, they're just trying to make sure that the courts aren't overloaded with these Lemon Law claims. They want to get a resolution done. They want to get the car fixed. They want everybody happy and just move on without them having to intercede. So what we have is, 3 different types of states. We have states that require the notice. We have states that don't require it at all. And then we have states where they kind of leave it up to you. So I'll start with states that require it. So states that require the Lemon Law notice are Georgia, Ohio, and Maryland. You are required to send the manufacturer notice via certified mail, return receipt requested, listing what your defect is, how to reach you, and things of that nature, which is something that us as a law firm handle for our clients. But there's information that you put within that notice, giving them a final attempt to repair, and they have a certain time limit to respond to and perform that repair before you can proceed with the lawsuit. And then I'll let Courtney, you can talk about states that don't require it, and then wonderful New Jersey.
Yeah, exactly. Pennsylvania, very simple. They do not require it. You do not have to give that last chance opportunity to repair. You don't have to send that letter. New Jersey, it's a little wishy-washy. They say, so remember when we're talking about the Lemon Law, what the Lemon Law says is the vehicle has to have been unable to be repaired in a reasonable number of attempts. What's reasonable? Generally more than 3, and 3 is kind of right on the cusp of reasonableness. So what New Jersey says is there is a presumption that 3 is unreasonable. If you brought it back 3 times and the problem continues to exist, it will be presumed that that's unreasonable, but only if you send that last chance repair letter. So if you want to avail yourself of that presumption that 3 times is unreasonable, yes, you're going to send that letter. So it's safer to send the letter. But if your vehicle has been back 7, 8, 9 times for the same problem, I don't think anybody can argue with the fact that that is not reasonable. So if you haven't sent that letter, not the end of the world. We usually just like to send it to be safe, because why not avail ourselves of that presumption? But you certainly don't have to when you're talking about a problem that's been subject to repair several times.
Yeah, it's just, what I say is it's more of just removing the argument, right? Because if we do have to litigate it, them filing these motions for not sending that letter just increases the timeline, right? It just gives them something to argue with us about, even if they just think they have a fighting chance, even the smallest % chance that they could be successful, they're going to fight us on it. So I say we're removing the argument. We're just taking it away. Whether they respond to the letter or not is up to them. But at least we can say we sent it, it's done, move on, let's get this finished. And also, like we said, a lot of these cases do resolve themselves in the pre-litigation process. So the letter is sort of 2 birds for us, right? We get the letter out, we get the notice, we can check that, box off our list. And it starts the conversation between us and the vehicle manufacturer in terms of what can we do here? How can we get this, resolved? And then the only other real requirements, and I apologize, New York does not require it. That was the only state I don't think we touched on. But the only other real requirements are that you continually bring the vehicle back to the dealership as you're having trouble. Because the main basis that binds all of these Lemon Laws is that you give the manufacturer a reasonable opportunity to cure the problem. And it's when they are able to do that, that the Lemon Laws come into play. So really just making sure you get it in, making sure you get those repair orders, and sending out notice are the main obligations of the consumer.
Yeah, Absolutely. And we always tell people keep those repair invoices fresh. A lot of times people will kind of give up, like, I've already been back so many times. I really don't want to have to keep going back. But if it's been 6 to 9 months since you've been back, you definitely want to get it back. Keep them fresh. That continuity is extremely important.
It is, because a lot of manufacturers use these failures as a defense. So, like we talked about previously, the lack of, the proper notice. And in states where it's required, that's a big issue. But in states like New Jersey, they'll use it just so they have something to argue with us about and some sort of motion they can file to, just prolong the litigation phase. So there's different sorts of ways that they can, bring defenses in these cases. And we've kind of broken them down into, process style defenses and substance of your claim. So process style defenses would be things like they failed to send notice, they didn't notify, bring the vehicle to the dealership enough times, or they went to drop the vehicle off and the dealership told them that they didn't have time, but they need to come back on such and such date. They never came back. So there's different steps that you do need to take and that you do need to follow, because the defense will use that against you moving forward. And there are other ways too that they can try to defend it in terms of the substance of the case. And I'll sort of let Courtney handle those.
Yeah, absolutely. Kind of we touched on it before, but was the vehicle back 3 or more times within the time period and the mileage requirement? Did the issue substantially impair the use, value, or safety? That's what we mean when we say the substance of the case, not the whole nonsense about the informal dispute resolution system and the last chance repair. So you're now in court, you've gotten there, the process was correct, but do you meet the threshold of whatever state's lemon law that you're trying to argue? And sometimes we're kind of able to help our clients out. Sometimes there's more than one state's lemon law that we could use. We kind of have a choice. If a vehicle was purchased in one state but registered in another and repaired in both, sometimes we're actually able to choose which state's lemon law do we want to plead in our complaint. And some lemon laws do give us more time. New York, for instance, is a very tough one. It has to be back 4 times within those 2 years or 18,000 miles. New Jersey, like we mentioned, is only 3 times within 24,000 miles. So sometimes we're able to help our clients out, make the case a little bit stronger, depending upon which lemon law we put into our complaint.
And the lemon law that we use does not always necessarily dictate where we have to file. So, for example, we have a lot of New York, New Jersey crossover, right? Because they're so close together, or PA, New Jersey crossover. So let's say, for example, a New York resident leased a vehicle in New Jersey. New Jersey is much better about leases than New York is, right? But for some reason or another, the New York lemon law in terms of the 4 visits and the repairs and things of that nature fit better. We can file the claim in New Jersey under New York lemon law if that works better for our consumer. And we're always looking at different things like what is the court setup, right? So is New Jersey going to be a faster way to get this done? Is New York going to be a better way to get this done? So we have sort of the ability to look at the case, see where it qualifies, what state it qualifies in, what venue works best for the case, in accordance for how to best facilitate this lemon law claim to make sure it's its strongest.
Yeah, absolutely. Like you mentioned, sometimes the court system is different. In New York, for instance, there is no arbitration program. So when you file a lawsuit, these cases are really just sitting there, often for about 2 years until you get to trial. Whereas New Jersey and Pennsylvania have an arbitration program, and they were designed to kind of weed out a lot of these cases, these lemon law cases, personal injury cases, so many types of cases that really can be settled and don't need to go to trial. So they have this arbitration process that really does work. I would say about 90, if not 95% of these cases will settle at the arbitration level. So it makes the whole process a lot faster. And that arbitration process can even differ between different states. In New Jersey, for instance, it's a bit more informal. In Pennsylvania, it tends to be more formal, almost like a little mini trial where rules of evidence and discovery are going to apply. New Jersey, it's almost like a glorified settlement conference. And it really does work quite well. Generally, these cases are able to get settled. So when we can file in one of those states that have the arbitration process, it's generally advantageous to our clients rather than filing in a state like New York that does not.
Right. All of that comes into play because these lemon laws, they're so nuanced, right? It seems sort of on its face like, oh, it's pretty basic. I just have to have the visits within this timeline. But when you get down to the nitty gritty, there's a lot of differences between them. And that's why it's important to have counsel because we know what those differences are and we know what can be more advantageous for you. I mean, it can even come down to the lemon law calculation. So every state, in addition to what we just talked about with the actual court system, the lemon law itself, in terms of, so let's say you do get the buyback, you do get the repurchase. A lot of clients ask me, well, are they going to try to lowball us? Are they going to try to give me some calculation that's not my full value? Well, they're not really allowed to do that because the lemon laws in each state actually have within them a lemon law buyback calculation. What's tough is, again, they're all different and some are better than others, but they can't really do that because the law doesn't let them. And that doesn't necessarily, though, always mean that the calculation is the greatest, right? So I'll let Courtney kind of talk about, there are some differences. For example, maybe talk about PA versus New Jersey.
Yeah, absolutely. So these numbers, they really can't be negotiated or finagled. I mean, the calculation, the formula that's used to decide how much money, how many dollars you're actually getting back as a result of these repurchases, it's a formula that's written right into the state statute. And Emma, like you mentioned, some are better than others. In New York, for instance, you're not going to get back your sales tax. You will eventually get it back from the state, but it's a different form that has to be filled out. We'll usually fill it out for our clients and streamline the process, but it's just, another step that has to be taken. Pennsylvania, for instance, a lot better. You're getting back everything. You're getting back your sales tax. Same with New Jersey. There is that mileage offset, though. New York, although you have to take that extra step to get back your sales tax, there's no mileage offset unless you're over 12,000 miles. If you drove that vehicle 11,999 miles, you're not being docked for those miles. Pennsylvania and New Jersey, you are. And there's differing formulas in each of those states to determine how much money is going to get subtracted. So what you're going to get back is your down payment plus all of the monthly payments that you've made to date, minus that mileage offset, which is essentially docking you for the miles that you put on the vehicle. Hey, you were able to drive the vehicle this many miles, so we're going to subtract this amount of dollars from the money that you're getting back. Pennsylvania, it's pretty straightforward, 10 cents a mile. New Jersey uses this kind of crazy formula. It's the purchase price multiplied by the miles when the problem started. Get that? All divided by 100,000. So you're kind of going back to high school math. First do the multiplication, then do the division. And sometimes it can equate to kind of a large mileage offset, especially if you have a more expensive vehicle, because remember, you're multiplying it by the vehicle's purchase price. So for a very expensive vehicle, if you drove that vehicle 10,000 miles, let's say, it's going to be a sizable mileage offset. Whereas if you have a more inexpensive vehicle, it'll be a little bit less, which is kind of not fair. You're paying more money for the vehicle, yet they're docking you more. But so that's why it's another thing that we want to think about when we're deciding what state we'd want to bring or what state's lemon law we'd want to plead in our complaint.
Right. And similarly, so because you had referenced getting your down payment and your payments back, and that works in some states. So for example, in New York and New Jersey, if you purchased a vehicle, you are entitled to your purchase price back. So New York specifically would not include your interest. So you're not getting your payments back necessarily in New York, unless it's a lease, right? Because there's no other way to calculate it. But if it's a purchase, let's say you bought the vehicle for $36,000, right? That's the amount that you're going to get back, the actual purchase price of the vehicle. They add in some, documentary fees and registration fees and things of that nature. But in terms of the interest that you're paying on your monthly payments that is part of your loan, that doesn't necessarily come back to you in every state. So that can make it tricky too when it's just the purchase price coming back to you. So it's not a true one-to-one always, which is tough, but it usually is pretty close. The only item in which no state is responsible for under lemon law is negative equity. So let's say you purchased or leased a vehicle and you traded a vehicle in to do so. And on the vehicle that you traded in, you have what's called negative equity. So negative equity would mean that you owed more on the vehicle than it was worth. So let's say you had 15,000 on your loan and they gave you 10,000 as a trade-in value, and you took that remaining 5,000 and you rolled that into your financing or your lease price. The manufacturer's not responsible for that. And so that will get deducted from the money that you get back. And sometimes that can be fine. You're far enough into your loan where you paid that off, you've paid it down, and you're good to go. And then I've had other cases where the client is still upside down and they've actually had to pay money out to get out of the vehicle. And that's a tough pill to swallow. Yeah.
Yeah, I'd see the exact same thing. Sometimes you look at it and you kind of, am I looking at this right? That they would actually have to pay a certain amount of money to get it bought back. But when you stop and think about it, it really does make sense, because why should the manufacturers have to pay off your negative equity to buy back this vehicle? That means they're essentially paying off your loan on your previous vehicle, not the Lemon. So it really does make sense when you think about it, but it's definitely something that a client's going to want to keep in mind. If they have negative equity, especially a lot of negative equity, they may not want the buyback. They may be better off taking a cash settlement if we can get that instead.
Yeah. And we've had that before where we've gotten the repurchase figures and I don't want to say they're no good, because they're all done pursuant to the state calculation. So it's not like anything nefarious is happening or things that they're not allowed to do. It's just the breakdown isn't great. And the value of the car itself, with whatever cash payment maybe we can get, puts them in a better situation. So these are all things that we review and look at when determining whether the buyback is the right thing for our client. So just all things to take into consideration. And again, varies per state. Another item that's different in each state in terms of just lemon laws in general, for example, is New York and leases, right? New York is not a huge fan, I guess I'll say, of leased vehicles. They've determined that, so usually, as we've always talked about, right, you can get your buyback or maybe you can keep the car and get cash. New York basically has said that leases really only qualify under lemon law. So all your eggs are in that basket, which can be tough. But then you have other states like New Jersey that's like, oh, even if your lease is up, you can still have a lemon law claim, which just does not happen across the board. In most places, once that lease vehicle is gone, your lemon law rights are gone. But that's a big difference between these states, along with statute of limitations. I'll let you talk a little bit about how that, affects these cases too.
Yeah, the statute of limitations can be a little bit different in each state as well. Some states, it's 4 years. Generally, it's about 4 years from the time that the vehicle was originally put into service. But again, each state can be different. And that is a hard and fast line. Whereas with the lemon law, when we're talking about, was the vehicle back multiple times within this amount of time, that as long as it was, and we can still be over that, even if, like we had mentioned before, okay, you're now at 38,000 miles, but it was back 3 times within the first 24,000 miles. That's okay. You've still got that lemon law claim. But with the statute of limitations, if you're over that statute of limitations, that is a hard and fast line. We would not be able to file a claim. And in fact, no one would. But that's always something that we're going to be very aware of. Even if we're not taking your claim, but we notice that statute of limitations is coming up, we're going to let you know that. We're going to send you an email. We're going to also tell you verbally, hey, look, we're not able to take this claim. Perhaps another attorney would, but please be advised that you're coming up on the statute of limitations. And once you get to that point, you're not going to be able to file anything for this vehicle.
Right, because the statute of limitations is the timeline to bring a case. So the courts basically say, hey, once a vehicle hits X years old, you no longer can bring a lawsuit. And that's a really hard one to fight against because it's a pretty hard and fast rule. Now, some states do have tolling. So New York, for example, like you said, hard and fast to 4 years, which is really tough. And we've tried to fight it before, and it's an uphill climb. Because even though your warranty may be 5 years, 60,000 miles, right? It's longer than the statute. New York has still decided in most counties that the 4-year statute of limitations is hard and fast, and there's no tolling it. Whereas, Courtney, I'll let you talk about the repair doctrine that they have in New Jersey, which gives you a little bit more flexibility.
Yeah, New Jersey tolls it. Let's not skip over Pennsylvania, though. Pennsylvania says it's when you knew or should have known of the problem. That's when the statute of limitations begins to run. So you first noticed this problem 6 years ago. You're just now bringing a claim. Probably not so good. Or should have known about the problem. So if you didn't notice it, but a reasonable person would have noticed it, that's when it's going to begin to run. New Jersey, however, is going to toll it under the repair doctrine. As long as you continue to repair the vehicle, continue to subject the vehicle to repair for that problem, it's going to continue to extend that statute of limitations. The theory is that, well, I got it fixed this time and I thought it was good to go, so I didn't think I had to bring a lawsuit. And now I just fixed it for the fourth time. Well, and now I thought it was good to go, so I didn't think I had to bring a lawsuit. So each time you get it fixed, it's kind of starting that statute of limitations over again, which is very beneficial.
Yeah, PA and New Jersey let us push it out, which is nice. It gives you more time and flexibility. Ohio and Maryland also have a 4-year statute of limitations. And Maryland actually has a 1-year statute of limitations when you're dealing with a leased vehicle, which is a very tight time frame. And then Georgia is, again, it's whole other animal. So Georgia's statute of limitations is so the Georgia Lemon Law period is 2 years, 24,000 miles, right? To bring your vehicle in and get those repairs done. Once your vehicle hits 2 years old or 24,000 miles, whichever one hits first, you have 1 year from then to bring your Lemon Law claim. So you have to keep track. You have to notice it. You have to kind of know when you're hitting that. And fortunately, the repair orders, if you don't remember, can kind of give us a good idea because they have the mileage on them and the date. But it's very strict, and you want to be aware of that. And then in terms of bringing a breach of warranty case in Georgia, or, as we talked about, our old cash and keep type case, you have 4 years from the original purchase, which again, all of these statutes, with the exception of PA and New Jersey, where you can kind of move them out a little bit, they start from when the first person bought the vehicle. So again, we kind of flow back to clients calling in and saying, well, it's a used vehicle, it's a 2019, but I didn't buy it until 2021. I haven't even had it for 4 years yet. But unfortunately, it counts from when the first person bought it. So we always are pulling Carfax reports to see when it was first put into service, so we can be very mindful of those time frames.
Yeah, absolutely. Because like we said, it is a hard and fast law, hard and fast rule, part of the law. And yeah, even if you've just gotten the vehicle, sometimes, unfortunately, that statute of limitations can already be expired.
And there are a lot of resources online to assist you with knowing this information. So the Attorney General's office is the best place to start, right? The Attorney General's office usually has all of this information delineated on it in terms of your time limits, the visits, the notice requirement, and things like that. States have tried to increase awareness of all these details as well by, I don't know if you've ever noticed, Courtney, that when you've purchased a vehicle, they give you usually a copy of your Lemon Law Bill of Rights, right? You get it in this stack of papers when you're financing or leasing a vehicle that you sign off on saying that you've received it and read it. But I think, when you're buying a vehicle, there's so much going on, you're not always really paying attention to that. But those are ways in which states have tried to really facilitate and push along the Lemon Law so consumers understand their rights, but it's not always, a most, effective means. It can be really tricky to know where to go when you start having these issues. Consumers also always have our website too, lemonlawcar.com. We try to be as inclusive with information as we can on there. Again, it's just for informative purposes, but we have a Lemon Law buyback calculator. We have a specific tab that goes state by state in terms of your rights and remedies and all sorts of different blogs. They can also assist consumers in figuring out where to go, what to look out for if they think they might be at the beginning of a Lemon Law claim or in the midst of one. And so there's lots of resources there for you. And also, like we said, the state's Attorney General's office can be super helpful with this. And on that note, I think we will leave it for today. And we thank you for your time and attention. And we hope to talk to you soon. Thank you.
Thanks, everyone.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.